Well, good afternoon, everybody. I
Afternoon.
Good afternoon.
appreciate council and the parties being so cooperative. Sorry, we had to do a last minute change in terms of having in-person versus Zoom, but judges are people too, and sometimes things come up. So again, appreciate your understanding for that. I'm Judge Edwards. I'll be presiding. Joining me today on the panel are Judges Eisnagel and Judge Kilbane. And we have two cases on the docket here at 1 o'clock, and we'll wait the next 10 seconds or whatever it is till it's officially 1 o'clock till we start. If you have any noisemakers, please put them on silent. Don't turn your mobile phone all the way off. If somehow or some reason we lose you, that's how we get you back. So we'll deal with that. It's now officially 1 o'clock. So welcome to a oral argument session in front of the Fifth District Court of Appeal. The first case we have on the docket is 24-1870. And is that Schlechter? Is that how you say that?
Yes, Your Honor. It is Sletcher or Sletcher. I don't think it matters.
Okay. Versus ARCPE Bahamas, etc. And that's 24-1870. We also have at the same time case 24-1872, Miller versus ARCP Bahamas LLC, etc. Each side will have 20 minutes. You'll have 5 minutes for rebuttal time for the appellant. There is a clock up in the corner there. 20 minutes is your total time. The time showing on the clock always will be what's left. If you want something other than 5 minutes as rebuttal time, let me know. The yellow light will come on when you're into your rebuttal time. It may not be always that easy to see on the TV screen here. So if I see you seem to be going on into your rebuttal time, I'll let you know. But it's your time and you can use it however you choose to. So with that, uh, counsel for the appellant, if you will let me know what you want for rebuttal time, and then you may proceed.
5 minutes is fine, Your Honor.
All right, you may proceed. Thank you.
Thank you. May it please the court, Brian Bull on behalf of the appellants. As the court noted, I represent the Sletchers and the Millers. There are four different lawsuits that were filed. The procedural aspect of each one of the cases is slightly different. They're ultimately consolidated with about 60 other cases. The court conducted some consolidated hearings before and after the issues were consolidated. I don't believe the actual procedural aspects are an issue at this case with regards to that. The legal issues on appeal are rather straightforward, Your Honor. The note holder unequivocally accelerated the debt as to the Sletchers based upon or on March 19, 2010, pursuant to a February 16, 2010 letter, as to the Millers on June 6, 2011, pursuant to a May 6, 2000 letter, and the actions were barred by the 5-year statute of limitations. All the notes with regards to my clients, the next argument does not have that. All the notes as to my clients contained a contractual permanent waiver of statute of limitations at inception. Although no Florida court has addressed this issue, the law in Florida must be such that it's unenforceable as against public policy. There's also some issues with regards to standing, attorney's fees, prejudgment interest. I'm not going to focus on those in this oral argument. I will answer any questions. I will probably
Counsel,
do some.
the statute of limitations, that's an affirmative defense, right?
Yes, Your Honor.
Why
And
is that, why is that not waivable?
uh, it would be waivable if at a future date. But with regards to, as set forth in the other case law that we cite, it is a matter of public policy. The statute of limitations is a matter of public policy. It's a statute designed to protect the public. If you could waive the statute of limitations at inception, every contract, every credit card agreement, every agreement you can think of in the state of Florida would have a waiver of the statute of limitations. I would say the statute of limitations is like a state imposed speed limit, but for time. You can go under, but you can't go over. It sets forth the maximum time in which a statute of limitation, or I'm sorry, not a maximum time statute of limitation, a maximum time in which an action can be go forward. There are possibilities where waiver can occur. They can occur as part of a forbearance agreement, but that's also at the time that the statute of limitations has already begun to run. There's a default. You enter into a forbearance agreement. There's consideration given. Also, they have
But why is it any different than any other statute? I mean, the legislature, the statute doesn't say it's not waivable, right?
Correct? That you are
So,
correct. That is correct. But there's also, and I don't know if you were done, Your Honor, but
no, go ahead. Yeah.
there's also other statutes. There's consumer protection statutes. You can't waive those. There's usury prohibitions. You can't waive usury. I can't go in to enter into a contractual agreement and say I will agree to pay 40% interest. That's non-waivable. There's no statute that says you
Because
can't.
I mean, that rate would be illegal, right? It would be an illegal rate, interest rate, right?
Correct. That is correct.
Right. So, I mean, is it a crime to charge a usury interest rate? Is that a crime?
The answer is yes and no. There's also there's criminal usury and there's usury that's not criminal. So with regards to my prior answer to your question, I guess I would have to modify it. It's yes and no. There is criminal usury, but there's also civil usury that's above a certain interest rate that's not criminal as of yet, but it's still not enforceable. I'd also say with regards to bankruptcy, you can't waive bankruptcy protections. I can't enter into a contract that says I will not file bankruptcy in the future because that's a right that I have to do.
Are there any of those that are affirmative defenses?
I believe bankruptcy is an affirmative defense. I think you have to raise that. I would say some of the statute.
In what way is a bankruptcy an affirmative defense?
If a plaintiff files a lawsuit against a defendant and the
Right.
defendant has declared bankruptcy, it would be an affirmative defense for the defendant to raise in that action. If they don't, then they waive it.
Are you talking about the stay?
No, even if I go through bankruptcy, if I
Right.
go through bankruptcy and the stay is no
Oh,
longer
if it's been
there,
discharged.
discharge, yes, sir.
Okay, you're talking about discharge.
Discharge. That would
Okay.
be an affirmative defense.
Okay.
That I would
And
have.
you're saying discharge is not waivable. So if it's not raised as an affirmative defense, you can raise it 10 years later.
No, if you do not raise it as an affirmative defense, I don't think you can raise it later on. I think you have to raise it in that action. So it would be just like any other affirmative defense, something that's waivable. It's not like a statute of repose.
So is there a statute is there an affirmative defense like the statute of limitations that you can point to that shows us that, hey, even though this is waivable, as an affirmative defense, it cannot be waived in a contract?
Was your question, can I point to a statute that says that it
Can you
can't?
point to anything? That's what your argument is for statute of limitations, correct?
Yeah.
That's your argument.
That is my correct.
Can you point to any other concept in the law where that principle applies?
Yes, Your Honor. You cannot waive protections that are set forth for the benefit of both the individuals and the public. And the statute of limitations is the public policy within the state of Florida.
No, I'm asking an affirmative defense. Specifically an affirmative defense that cannot be waived in a contract, but obviously because it's an affirmative defense can be waived if not pled.
I would say you can waive defenses in a contract. I think you have to look also whether or not the waiver is knowing intentional relinquishment of a known right. I don't know with regards to this situation that was ever flushed out. Also, with regards to what your argument said right there, the same argument would be made to ARCP, the appellee, as to the Millers because they didn't raise an avoidance to the statute of limitations. So they would have waived the waiver argument by not raising it to the statute of limitations. Statute of limitations were raised as an affirmative defenses in all four of the lawsuits. They filed a reply in two of the lawsuits, but two of the other lawsuits, the Miller lawsuits, they did not file a reply. So under your logic right there, they waived the waiver argument because they didn't.
Was the contract attached to the complaint in which?
Yes.
Okay.
And
so would they need to avoid an attachment to the complaint controls, right?
It controls for stating the cause of action, but the cause of action, all you need to do is allege the elements of the cause of action. The cause of action for a breach of contract is the existence of contract, default, and damages. You don't plead all the avoidances that you need to do. That's something you have to do in a reply. So they wouldn't put in there.
But if the complaint itself, if the attachment to the complaint demonstrates the avoidance already, is that you're saying that you still have to file the reply even though it's already established in the complaint?
I would say yes, Your Honor.
Okay.
But that also
excuse me, counsel. Let me ask you, how do you differentiate the CCM Pathfinder case here, I understand from your briefs that you say, well, they can still raise the statute of limitations as an affirmative defense to contest or raise factual issues. But in CCM Pathfinder, as I understood it, the Court of Appeal treated the complaint, which included the fact that the statute of limitations had been waived. They looked at that and said, well, it's facially valid. Well, if the waiver of statute of limitations was contrary to public policy and unenforceable, how could that complaint have been facially valid?
Because they attached the mortgage to the complaint, the court was required to accept it as part of the allegations. So they couldn't dismiss it on a motion for some or motion to dismiss stage. They could as to a motion for summary judgment on the affirmative defenses. The CCM case was also limited to the circumstances where they held only that the dismissal of the complaint based upon the statute of limitations was erroneous, and that on remand they could still raise the argument as an affirmative defense as to the lack of statute of limitations.
But they said raising certain facts. You're talking as though waiver of statute of limitations as a matter of law, since it's against public policy, that you cannot do that. You cannot enforce that. You don't need any facts, do you?
Yes and no, and I don't know why the appellate court, I don't know if that issue was raised. And if that issue wasn't raised, that wasn't something they would have decided. I wasn't present at that argument. I didn't look at the briefs. I looked at the opinion. I looked at what happened afterwards. And I would state that I would tend to agree with you that it probably could have and should have been decided on a motion to dismiss stage if they raised at the trial level that it was unenforceable as against public policy. I don't know if they did that. And if the court looked at that point, then they could have determined, and also that the other issue is maybe that would have been something outside the four corners of the complaint, because now you have to take the public policy considerations, and that's not something you should look at when you're dealing with on a motion to dismiss. I don't know the answer with regards to whether they can or can't on a public policy issues. I do know that Florida has not addressed the issue. I do know from all the other cases that we cited in we do a footnote with regards to cases that we cited in the underlying trial court level, that every other court that I've looked at, Williston on contracts, Corbin on contracts, have stated that contracts that permanently waive the statute of limitations at inception are unenforceable as against public policy, because if you could do that, then there would be no purpose for a statute of limitations. What they would do is they would put in every contract a waiver and would completely annihilate the statute of limitations. And the statute of limitations is the public policy of the Florida legislature as to when lawsuits should be filed.
Every statute's the public policy of the Florida legislature, is it not?
I would agree with that.
Okay. So why, I mean, you can't waive any of it? If it's in a statute, you can't waive it?
If it's designed to protect the public, I do not believe you can do so at that
Isn't
time.
every statute, I mean, quote me a statute that's not in some way designed to protect the public.
All the statutes with regards to the creation of the circuit court, the county court, the
circuit courts are important for the public.
They are. I would agree with that, but it's not it doesn't express the public policy of the state.
Let me ask you this.
Counsel, go ahead. Go ahead, Judge.
I had questions about prejudgment interest. So go ahead, Judge Edwards, if you're still on this issue.
No, that's fine. We have limited time, so that's a question we need to hit.
So on prejudgment interest, I believe, as I read your brief, I believe you say, hey, look, the evidence was insufficient. Let's assume for the moment the panel agrees with that. Okay, assume for the moment.
Yes.
You ask that we remand for nominal damages. My question is this: I believe, as I've read the note, my understanding is it was, the note says LIBOR plus 3.5%.
Correct.
If they didn't prove LIBOR, why shouldn't we just assume LIBOR was 0 because they didn't prove it, and they get 3.5% on remand?
That is a possibility, except for the fact that LIBOR could have been a negative rate, and at some point, with regards to other LIBOR rates, they did go negative at one point.
Does our record demonstrate that in this circumstance it could have gone negative?
It doesn't record, it does not reflect one way or the other. There was testimony of the witness that he does not know if the rates ever went negative. And I would also point out, I don't know if it's up for the court to do.
But they conceded. Well, I mean, look, if it was impossible for it to go negative for some reason, then it would be, and that's demonstrated in the record, then it would be our business, right? But you're saying
I would agree with you, Your Honor.
The parties agreed below that it's possible to go negative, but they didn't know if it did.
Based upon your initial part of the question, Your Honor, I would agree. If the rates never went below 0, and that's the floor, then it would be 0 plus 3.5%.
But does anything in the record itself establish that LIBOR can go below 0?
No, it doesn't establish that it could. It doesn't establish that it couldn't.
Okay.
Either way, there's nothing in the record either way.
Thank you.
Counsel, explain to me briefly how you distinguish between the intent to accelerate, which a lot of cases talk about, versus has accelerated, in terms of that very significant difference, and how this one fits in. I understand it says if you don't pay within 30 days, we will accelerate and it will become immediately due. So I understand it's a fine line there, but you tell us how you can pull us over that line.
I can do so, Your Honor, and I may go over my 5 minutes with regards to this. So there's no prohibition under the law that requires acceleration before or after. You can do both of them. This particular provision contemplates notice of acceleration will occur prior to acceleration. If you read the actual terms of Section 7C, it makes it clear that they are to provide you with notice of acceleration before it's accelerated. And the end of the sentence says that date must be at least 30 days after the date on which the notice is mailed. The two cases that were cited in the lower court and by appellee, Snow and Graybush, it's not unequivocal. It's maybe. It did not automatically accelerate. Absent from the letters, either one of them, is that there would be immediately due and payable. The default could be accelerated at some future point after the default date. Specifically, if you read the actual acceleration letters, or the letters, however you want to refer to it, it states clearly, number 7C says, Section 7C says, if I'm in default, the note holder may send me written notice telling me I'm in default, and that they may accelerate. The acceleration letters say a default happened. We're notifying you of the default. We have rights. It says the right to declare such note to be immediately due and payable in accordance with set forth in Section 7C. And then in all caps, bold, the letter then says, demand is hereby made for payment. Please accept this as written notice pursuant to Section 7C of the note, which is the acceleration provision. If you do not remit payment for all overdue amounts within 30 days after the date that this letter was mailed to you, the entire outstanding principal will become accelerated and immediately due and payable without further notice to you. The letter unequivocally notifies the borrowers that if they don't cure in 30 days, the debt is accelerated, immediately due and payable, and no further notice would be given.
No, Counsel, I understand all the language. Again, the cases talk about intent to. I mean, for me, if I haven't lost 10 pounds by the end of December, I'm going to immediately start a diet January 1st. That doesn't mean I have started a diet. And that's what the cases talk about, intent versus actually done it. And you're down to about 3.5 minutes. If you want to take your time and think of a good answer later, that's fine. Or
I can tell you right now, there is the intent. It's a clear intent to accelerate. They tell you nothing in the words indicate that the acceleration was optional. It says if you don't pay by this date, it will be accelerated, immediately due and payable without further notice. So, for example, I'll give you an example. If you owe me $100 and are making $10 installment payments, you fail to make an installment payment, and I inform you that you're in default. And I then tell you, if you don't cure that default by the end of oral argument, the entire amount will be due and immediately payable. I'm not going to give you any further notice, and you don't cure the default by the end of argument, the debt became accelerated. I don't have to give you any further notice. It's due and payable. I've just told you. I told you if you don't pay me by the end of the argument, it's immediately due, and I'm not going to tell you again. So if that answers your question, I'll reserve the rest.
That's good for now. Thanks. All right. Which of my other attorneys here are you both gonna argue or just one?
Just me, Your Honor.
All right, great. Go ahead whenever you're ready.
Thank you, Your Honor. May it please the court, Mark Gottlieb with Ackerman LLP on behalf of Appali ARCPE Bahamas. Unless the court wants to direct me in another direction, I'm going to focus argument today on the statute of limitations issues and the prejudgment interest issues. There wasn't any argument really advanced on the standing question and the attorney's fee question. I think we can let our briefs stand on that unless the court has specific questions regarding it. With respect to the statute of limitations issue, the law is pretty crystal clear that an optional acceleration provision in a loan, in order to effectuate an acceleration where the loan provides for optional acceleration, that acceleration must be done by some clear and unequivocal action, that the option has been exercised and that all amounts are now due and payable. That's the Central Home Lippincott case, which both parties cite. And that case says expressly that kind of clear and unequivocal action, and I'm quoting, should apprise the maker of the fact that the option to accelerate has been exercised. Their argument is that a default letter, which is sent for a different purpose, which is to provide notice of a default and an opportunity to cure and warn of consequences, that kind of letter, if it says, if you do not cure, we will accelerate, that operates as some kind of automatic acceleration. The problem for them is that exact argument on really all four facts has been rejected by the third and the fourth DCA in the Snow versus Wells Fargo case and the Bank of America versus Graybush case. In both of those cases, the borrowers argued, just like appellants do here, that a default letter sent on a loan with an optional acceleration clause that says, if you do not cure your default, we will, or we shall, or your loan will, or your loan shall be accelerated, operated somehow as an automatic acceleration. And in both of those cases, the third and
What
fourth
about the
rejected.
without further notice to you language? I mean, that seems to weigh pretty heavily the other direction, doesn't it?
I don't think that it does. In both of the notices, in both Snow and Graybush, the statements on their face were conditional. They were conditioned upon whether you tendered your amount needed to cure your default, but they were otherwise definitive, right? If you do not pay, we will, we shall. There's no other condition there. It doesn't leave open the possibility that maybe we won't, or maybe we have to provide you with further notice. Adding that doesn't do anything.
I don't know. Could you accelerate here without any notice at all?
No, because acceleration has to be by clear and unequivocal action.
So if in order to accelerate, if you must provide notice, they've just said they're not going to provide notice. Doesn't that seem to suggest that this is the notice?
No, they've already provided notice with respect to the default.
Right.
So the same pertains to the language in Snow and Graybush. It said the same thing. This will happen. We will be accelerating if you do not.
But what does without further notice mean? How do you provide a notice of acceleration without providing a notice of acceleration? How do you accelerate without the notice?
You could accelerate by providing a separate notice. You can accelerate
no. Counsel. It says without further notice. It says without notice. How do you accelerate without notice?
I read that letter as providing for notice and cure. You will not have any further opportunities to cure. This will be your last notice to cure. If you don't cure, then the next things will follow.
So
and that's what the Snow and Graybush letters said as well.
That's perhaps a reasonable answer. Your answer is the without further notice to you language. Is that the notice they're referring to is the default notice? There won't be any further default notice. There won't be further cure notice.
Correct.
Okay. All right.
The counsel, go ahead, Judge Kilbane.
Excuse me. And counsel, would it be your position that you don't have to provide further notice because you've provided this default, but you'd have to take some action, I would presume, like filing suit or something of that nature to actually accelerate?
Yes, and in every one of these cases where there was this type of notice, the courts ultimately found that the acceleration happened the way it traditionally happens in these installment loan or foreclosure action enforcement actions, which is by the filing of the complaint, which declares all amounts now due and payable. That's the standard traditional way that loans are accelerated, and that's the way they were ultimately accelerated in these cases, notwithstanding these earlier default notices.
Counsel, you can see how your opposing counsel might want to make that argument, though, based on the way this default notice is drafted. I'll be honest with you, that's the way I read it. The first time I read it, that's how I took it. without further notice at the very end? Where that phrase is right after the acceleration discussion, right?
I mean,
Could be
both.
this notice could be written much more clearly, right? If it means what you say it means.
Perhaps it could be, but it honestly, it mirrors the language in Snow and Graybush. Neither one of those, they all said your loan will be accelerated essentially without further notice. There's no qualifier there. Your loan shall be accelerated. There is no qualifier. There is no suggestion that there will be further notice. It is a definitive statement, but it's a conditional statement. It's a statement that says it will only happen if you don't cure the default. And it doesn't tell you what the amounts are to pay for this full accelerated amount that supposedly has been accelerated. And that's a critical distinction in these cases.
Is it your position that, look, once in the note itself, once if it's not an automatic acceleration in the note, then at that point you're dealing with the optional acceleration, right? And if you're dealing with an optional acceleration, that you can't then convert it into automatic within a default notice. Is that sort of your position?
Yes, you can't convert it to automatic. There's going to be a subsequent act of acceleration.
Isn't that what appellant's argument essentially would be, that look, it's optional in the note, but then the language of this default notice converted it into automatic. Isn't that essentially what they're arguing?
That is absolutely their argument. That was the same argument made in Snow and Graybush, that the language effectuate, because it said will, because it said shall, because it was definitive. If you don't cure, this is what's going to happen, that affected an automatic acceleration, and both the third and fourth DCAs rejected that automatic acceleration argument.
Counsel, let's talk about prejudgment interest for a minute. What proof did you actually put on of what LIBOR was on any change date? I know you had Mr. Brescher ultimately testify about here's what the interest owed on each note is. But I mean, Brescher, your claim in your brief is Brescher had personal knowledge. Did he work for one of these London banks?
No, he clearly didn't work for anybody who was actually promulgating the LIBOR or the SOFR rates.
Okay, so he had to hear about it or read about what the rate was, didn't he?
Yeah, I mean, I can review the testimony again. So it all boils down to these single variables, LIBOR and SOFR, which are daily published indices, which the courts
Okay,
can
so
and do typically
what
traditionally notice.
publications did you put into evidence?
No publications were put into evidence.
All right.
The testimony was this, and again, in the absence of countervailing testimony, we submit it was sufficient. The testimony was that he was familiar with both rates. He worked with them routinely. He knows where they are and who promulgates them. Number two, that they were routinely used and referenced in Apelli's business. Number three, and importantly, that Apelli maintained internal systems that tracked these things and imported this information from published sources. Admittedly, he could.
So they had their own database, but that was not admitted into evidence.
The database itself was not admitted into evidence.
The only evidence, and he had a chart with all the different evidence, with all the different interest amounts, that was not put into evidence.
The chart itself was not put into evidence. It was used to refresh memory and provided to.
Which is fine, but
opposing
the
counsel.
old thing, you
Yeah.
can use a plate of spaghetti to refresh memory. So
Understood, Your Honor.
that's not evidence of anything either. So what I'm getting to, and what the appellants did in their briefs was, great, you got this guy who's knowledgeable maybe and deals with this stuff all the time, but if you're going to have testimony, whether it's about publications, business records, whatever else, if the underlying documents are not in evidence, how can he base his testimony on it?
Because he was relying on what is in essence information that's the subject of judicial notice routinely, independently verified. This is not like a business record.
Well, it wasn't judicially noticed here, was it?
It was not judicially noticed here. The request for judicial notice was denied at the hearing.
Right. And he's not presented as an expert. He's a fact witness, correct?
Correct.
So again, you've got a fact witness who hears about, reads about, sees, knows from other sources, not personal knowledge, about certain information upon which he then calculates interest rates, and the court relies upon that. And again, my question for you is, I don't see the evidence in the record underlying his testimony.
Well, first of all, testimony itself can be evidence even in the absence of records. And I understand that there are cases that talk about offering testimony on business records without qualifying and admitting the underlying records upon which that testimony is based. This is a little bit of a different situation in those cases because we're talking about something that is an objectively verifiable, published index that courts do routinely take judicial notice of. It's not a business record. They don't
Well,
maintain
no,
it
I
other than
understand.
reporting it.
I understand that. I mean, it could be the same thing as the temperature you could verify easily if the court would take judicial notice of it. But, again, here that's a problem I had. And Mr. Brescher, if I'm saying his name correctly, he did not actually, he was not employed for any of the lenders during the time any of these notes was active, was he?
Mr. Brescher, I believe, was employed by at least one during the time the notes were active. Yes.
Did he ever say, here's what the interest rate was on this change date for the Schlechters or the Millers or whoever else?
No, he said that he determined what the rate was, LIBOR, SOFR, as of each change date based on the internal systems that they maintained, which imported the publicly available information and
I'm
used
sorry
that.
to interrupt you, but did he testify that on the change date for the Millers at this particular change date, here's what LIBOR was?
That specific testimony, no, only that he did that exercise, but he didn't announce on the record, I've determined that LIBOR was X number on this date. He said that he performed that exercise and did it to do his calculation, that for each change date, he looked at the information that they maintained internally as to what LIBOR was, used the note formula, and then made his calculations. But he did not announce on the record, I've determined that LIBOR was X% on this date.
And your opponents objected based on hearsay, among other things. Is that correct?
I forget whether this particular opponent did. This was a consolidated hearing, but there were definitely hearsay objections made.
All right. Okay. All right. Go ahead. I've asked my questions and you've answered them. So you go with your time as you see fit, or my colleagues see fit.
Counsel, if we conclude that the evidence was insufficient, is your opposing counsel correct that the proper remedy would be to remand for nominal damages?
We don't believe so. We've submitted a number of cases that say that in this context, the appropriate remedy would be remand for further proceedings on the narrow issue of what the correct amount of entitlement to prejudgment interest is. And I would cite the court first to the case of Gonzalez versus One West, which is out of the 4th DCA. I'm citing that because both parties cite to it. They cite to it for the proposition that the evidence was insufficient, but what they overlook is the last portion of the decision, which says, okay, you've established everything else you need to establish in terms of obtaining a judgment, including principal amount and everything else. The only issue is interest. And the court says, and the sufficiency of evidence as to LIBOR. And the court says, we're going to remand to the circuit court for a new trial on the interest rate to which the appellee bank is entitled. And we've cited in our supplemental authority as well, several additional cases, Hartz versus Wells Fargo.
Why are those cases correct though? Why, generally speaking, when there's an insufficiency of the evidence, we don't remand for a redo. I think the Supreme Court's called it a second bite of the apple, right? So generally that's not done. Why would it be done with prejudgment interest?
In this unique context, it seems that there are consistent rulings that where you are otherwise going to just go back and get your judgment and you've prevailed on everything else and you've proved entitlement to principal and the only issue is an interest rate calculation, court after court has remanded those for further proceedings to determine interest. In all the cases they cite, the failures of proof were far more extensive. They went to the failure to prove any amounts due at all, and then additional failures of proof, like for failure to prove conditions precedent, failure to prove lost note standing. So the remand was for an involuntary dismissal. These courts don't express a rationale, I will concede that, but in case after case where the only issue was a technical sort of ministerial calculation of interest based on really an objectively verifiable number that no one in this case has disputed. Nobody has offered contrary evidence. Nobody said that the calculations were wrong, that the numbers used were wrong. In that context, court after court has agreed to remand for further evidentiary proceedings to determine the proper calculation of interest.
Is it just what you would label the ministerial nature? And I'm not saying I agree that it's ministerial, but is that sort of the difference in why why you would get a second bite of the apple on this one, as opposed to, if you prove a breach of contract, but you don't prove any damages, pretty sure you don't get a remand to try to prove damages, right?
Agree that that's the general rule in this context, and the common thread seems to be that the only issue is a sort of a collateral amount where the parties otherwise prevailed on judgment, principle, proved all those elements, and the only issue is the sort of collateral calculation. In this case, a fairly ministerial one, given that the interest rate figures are all publicly available and generally the subject of judicial notice. In those cases, that's what has happened. They've been remanded for further proceedings. In the cases they cite, Clark, Figueroa, Wolkoff, the failures were far more extensive. The remands were for an involuntary dismissal because of a failure to prove your case at all. And that's the distinguishing feature in those cases. Even the Wolkoff case actually cites to a case which is much more similar to what we're dealing with. Wolkoff, which they rely on, cites to a case called Sass versus Fannie Mae, where the trial witness had presented testimony as to amounts due based on review of information and calculations that weren't themselves admitted into evidence, basically relying on notes of what he had reviewed, but without introducing the actual business records. That was allowed over objection, and a judgment had been entered in favor of Fannie Mae, but the appellate court reversed, finding the evidence was incompetent or inadmissible. But then, so they affirmed the underlying judgment, but then remanded for further proceedings to properly establish the amounts due, which is consistent with Gonzalez. It's consistent with Boyette. It's consistent with all these cases. They haven't cited a contrary case. I would also just note, as Your Honor pointed out, a fallback issue or argument is that at minimum, a floor should be the 3.25% addition to the LIBOR index.
What
There
about
was
what
no
about what
evidence
about
of-
the possibility that the index could have gone negative though? Doesn't that kind of mess up the floor?
We're talking about a theoretical possibility for which no evidence was introduced, and
Right,
I
but-
think it's fairly speculative. But yes,
Yeah, and it may be in this circumstance, it may be a highly unlikely scenario, but if it is possible, do you agree that it's possible?
I mean, I don't know or agree that it's possible. It makes no sense to me that one of these indexes would go negative and that a borrower, that a lender would essentially be agreeing to pay interest to the borrower as opposed to vice versa. It makes no sense to me. I can't tell you whether historically it's ever happened or whether it's happened to just like a de minimis amount. There's also the formula, I think, is 3.25% rounded up by the nearest eighth of a point. So you have to go negative by more than an eighth of a point to not at least hit that
So
floor.
I'll ask
And
you the
that-
same question I asked your opposing counsel. Is there any evidence in the record establishing one way or the other whether or not the index could have gone negative here?
I think Mr. Bull conceded that there is no evidence that the index could have gone negative. A question was posed to Mr. Brescher about whether he knew if it ever had, and his answer was he was not aware of it or didn't know.
Okay.
I think was the answer.
Okay.
And counsel, is it material that the other cases you referenced that were remanded for an involuntary dismissal, that those cases, they were trying all aspects of the case? Here, the only issue that was tried was the prejudgment interest. So it doesn't seem ministerial, or the court, at least below, didn't believe it was a ministerial act that if there was a whole trial on it. So do you think that impacts the ability of this court to remand to essentially for a redo?
I agree that that's a distinction, but I don't agree that it should matter here. I think the critical determination of these courts was that on this, if we're just talking about a narrow issue and ultimately there's going to be a judgment on principle in favor of the plaintiff, that there can be further evidentiary proceedings on that interest issue. I will note this, like the notion that there's in the foreclosure context that there will be no further proceedings, that you've had your bite of the apple, doesn't even really hold. And maybe that's why some of these cases we're thinking, because in the foreclosure world, you can sue on the next default. If you lose and get an involuntary dismissal, you can run back into court the next day and sue on your next default.
But that's a new
Singleton.
case. But but
But you
we
have the
see-
second bite of the apple to prove it all. And maybe that affected
not the
court's
same
thinking.
default though. Not on the same default.
On the very next default.
Or on the next default, but the prior default you've lost forever, correct?
The one default, but you're still going to have your bite at all the accrued interest that results from the
Fair.
next default and everything else.
Fair enough. Here's an important question on these cases that on the remand issue for prejudgment interest on whether or not you get another chance to introduce evidence on the index, that kind of thing. Are any of those binding on us?
I don't think any are out of the 50 CA.
Great.
Like I see, I've used all my time, so
Great. Thank you very much. Mr.
Thank
Bull,
you.
we're back to you.
Yes, Your Honor. I would also say, even if it isn't the 50 CA, I don't believe it's actually technically binding on you, but that's beside the point. The Under the notes, notice of default is not required. There is no provision that says I have to provide you notice of default. 7B says if I don't pay, I'm in default. 7C is the acceleration letter or acceleration notice. There's a key and important difference in the Graybush and the Snow letters. They do not mirror the language that were mailed to the appellants. There's a key omission. And it's set, and if you read the opinion of the Snow opinion, Third District states, quote, absent from the letter is any declaration by Wells Fargo that the full amount of principal and interest is immediately due, or any demand for payment of the full amount of principal and interest. And they go, therefore, the lapse of the 30-day grace period without a cure of the default did not automatically accelerate the debt. In the letters that were mailed to the appellants, it said, if you do not pay by this date, the entire principal, entire debt will become accelerated, immediately due and payable. They could have just as easily said a deadline, just like in the Graybush and the Snow. The letter in Graybush says that the default is not cured on or before December 17, 2008, the mortgage payments will be accelerated, and they don't have a date as to when it will be. But if they said and immediately due and payable, we know midnight, 101 or not midnight, 12:01 a.m. the next day, it's due, it's payable. They've just told you it's immediately due and payable. If they said,
Mr. Bull, according to the acceleration letters, the only condition is whether or not the borrower pays or doesn't pay, correct?
yeah, if I do not pay by the deadline, it becomes accelerated. That's what
And
it says.
they say in their letter they don't need to do anything else. If you don't pay, it's accelerated without any further notice to you. So that is their acceleration notice, isn't it?
That's correct. That's what I'm saying. That's my argument, Your Honor. That's my argument. The letter that they sent is the acceleration notice. They're notifying you that it's being accelerated. If you don't pay by this date, it's accelerated. They could have
telling
just
you, and they're telling you they don't need to do anything else.
correct. Correct, Your Honor. I would say prejudgment interest is an element of damages. We did provide a roadmap as to how to prove their prejudgment interest. They didn't do it. They didn't do what they needed to do. I didn't have enough time to make all my other arguments. For all the reasons set forth in the briefs and in the oral argument, the court should reverse.
All right. Thank you very much. The case was well briefed and well argued. So thank you very much, and we will be in recess.
Thank
thank
you.
you, Your Honor.